Good morning. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time you actually need. And remember that if the panel has additional questions past the time you've been allotted, we will ask them and you'll have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you have asked for less than 2 minutes, it will go on immediately. I want to recognize that we have present with us today a bunch of seniors from the Nest Plus M School from the Lower East Side. We welcome you. Lawyers, when I call your case, rise and please let me know how much time you are requesting. People v. Elliot Rodriguez, submitted. Judson Realty v. Judson CRE. Counsel, you're going to be the only person talking today, right? Yes. Okay, we'll give you 2 minutes. V. Nova is submitted. Nguyen v. Fan. 5 minutes. Would you like time on rebuttal, counsel? 1 minute. Okay, I'll give you 4 and 2 and 4. People v. Brandon Smith, submitted. People v. Christopher Landa. Four and 2 and 2. Mount Holly Insurance v. Michelle Kuo Corporation.
Good morning, Your Honor. We're requesting 15 minutes to be divided among the appellants. I am going to be arguing first, so I've asked for 8 and 2.
Are you from Mount Holly or are you from the other appellant? Is Mount Holly, oh, there you are. Okay. All right, we'll give you 6 and 2, 6 and 2, and I'll give you 6, counsel. You may not use it, but we'll see. Thank you. Kuteller versus Mamakos.
Just for the appellant, Your Honor, I have 4 minutes.
I'll give you 3 minutes, counsel.
Okay, thank you.
People v. Joseph Garcia.
Appellant requests 4 and 2. Respondent 4 minutes, Your Honor.
4 and 2 and 4. Stafford v. Naxon.
Appellant's request 3 and 3. Good morning, respondent request 3.
3 and 3 and 3. Pichardo v. the George units.
Your Honor, request 5 and 2.
Respondent requests
3,
3.
5 and 2 and 3. People v. Joshua Roman. Submitted. McLeod v. New York City Hospitals.
Appellant requests 5 and 2, please. Respondent.
5 and 2 and 5. HSBC Bank v. Nicholas. Seems you have no other side. 4 minutes? I'll give you 3 minutes. People v. Jeffrey Davis. Submitted. Lee v. Najad is submitted. Roche v. Hochfelder is submitted. Our first case up is Judson Realty. So, counsel, what's the status? Oh, give your appearance. I'm sorry.
Good afternoon, Your Honor. It's Brian Bernstein, Law Office of Brian Bernstein, PC, for the appellant.
So we got your letter. We don't want to get in the way of any settlement of the appeal, of course. We'd like to hear sooner, if possible, about such settlements. But what's the status of the STIP? Has it been signed?
The stipulation has not yet been signed. I sent it to council yesterday. There has been a settlement that was placed on the record back on September 30th in the guardianship action, which settled all issues in that action.
That happened on September 30th?
I'm sorry?
When did that happen?
September 30 of this
Why
year.
are you only telling us the night before oral argument then?
It's a sealed transcript, Judge, so we just received word about the settlement and the fact that we try to get a copy of the transcript so we could submit it to the appellate division, and that has not happened yet. So I spoke with counsel and said, would you be willing to sign a stipulation, since his counsel was in court, the petitioner was in court, my client was in court in the guardianship matter.
Yeah.
So we thought that they would sign off on the stip. They have the stip, they just haven't signed off on it yet. But we have been told that with respect to the guardianship action, all issues have been settled. None of those issues never impacted this matter.
I know that's your argument for sure, yeah.
Yeah, and they don't impact this matter. So we believe that once the stip is signed, we'll be.
Well, we'll put it on suspense for some period of time, counsel, but how long? We can't keep it there forever. So how long do you think it'll take you to get it done?
Well, that's up to opposing counsel. We sent them the stip. We thought it would have been signed last evening, and it wasn't. They sent that, which is why we sent the letter.
Well, say there's some inertia on the other side's part. You know, you have this appeal. You know, you want us to deal with it. So what do you want us to do?
Proceed with the appeal, and we will notify the court if they sign the stip this afternoon or tomorrow. We're going to submit the papers to the trial judge.
I'll give you some time to talk about the merits, but let's finish with the procedural part. What I would propose is that we hold it for a week. Is that enough time?
Enough time to come back for argument?
No, to come back with a stipulation telling us that you settled the case.
Well, Judge, that is my intention, but if Respondent's counsel doesn't sign the stipulation, then I'm left with wanting to proceed with the appeal.
All right, we'll give you 2 weeks and we won't do anything. I'm going to give you another minute to argue the merits. We've read your papers and we understand your argument, but go ahead.
So the first thing I just want to bring to the court's attention is that the court below did not look at or address the 2005 operating agreement of Judson Properties. In that agreement, that's where the authority is found for the commencement and the prosecution of the
Right,
underlying.
so that gave Stephen, I'll call him Stephen, the authority to bring this case.
I'm sorry?
Or that gave him the authority to tell his companies to bring
That's
this
correct.
case.
It's Stephen Judson. The court seemed focused on an attack in the guardianship action about a 1% interest that Stephen Judson acquired from his father. That is supported by an appraisal for $274,000.
Also, your argument is it wouldn't make any difference anyway. He already had a controlling interest.
Which is why we think the court below mistook this case as a matter as if the LLC was operated as a members as opposed to management operated. So that became the issue for the court below. We think on this record, the court should reverse the decision, vacate the stay. Motions for summary judgment were filed months ago. I think it's approximately 7 months ago from both sides. And if the stay is lifted, the court can then decide the motions for summary judgment.
All right, well, please let us know about the stipulation. Are there any further questions from the panel? Thank you, counsel.
Thank you very much, Your Honor.
Nguyen V. Phan. Please.
Good morning, Your Honors. My name is Patricia Grant, and I represent the appellant in this litigation. This action was commenced by the filing of a summons and an
Counsel, with regard to the insurance funds, were they not already placed in accounts and accounted for prior to the separation agreement?
No, they weren't.
There's no indication or evidence in the record of that?
There is an indication.
Do you mind using the microphone? I'm sorry, I can't hear you.
There was
Put the microphone closer to you. Thank you very much.
There was an indication that $89,000 was paid. That's the only proof we have of any payments that were actually deposited to the bank account.
Were the insurance claims accounted for in a separation agreement?
No, they were not. They were not.
Counsel, didn't the plaintiff have the opportunity to discover, through discovery, in the discovery period of this lawsuit, what happened to the insurance proceeds?
Your Honor, I didn't represent appellant in the lower proceedings, but there were bank accounts provided, and the respondent will argue that that the deposits from the insurance company were deposited to the bank account. There's no indication of that. There are deposits.
That's not really my question. Was she aware of the fact that an insurance claim had been put in?
Yes, Your Honor, she was.
Okay, so she had an opportunity before, in a given period, to do discovery on this question, did she not?
She did, Your Honor, but there was no, she didn't know when the insurance proceeds were received, whether they had been received.
Also, wasn't there a release signed in April 10th of 2018?
Yes, there was. It was signed by the respondent,
Just the respondent?
just the respondent. So, in fact, if you look at the bank accounts where the respondent claims that all of the proceeds were deposited, then the total number of deposits during the relevant period of time does not add up to the total of what was received from the insurance company.
Well, as far as I can see, about $460,000 of the proceeds went into the marital account. That was prior to commencement of this action, I forget when you did this, but it was before, it was by 2018, April.
The respondent claims that some $643,000 went into the marital account. But as I say, the marital account doesn't reflect deposits of the $643. It reflects deposits in total of about $597,000.
And part of that, there's $89,000 that went into the marital account prior to the settlement agreement. So I'm just curious as to why then your client didn't know about it.
Well, she was kept in the dark, basically. She didn't have access to the bank account, even though it was a joint account. The respondent was the only person that had the password to that account.
Well, isn't that the definition of a joint account? I mean, one can assert one's interest in a joint account, go to the bank and say, hey, I'm on this account, let me see the statements.
Yes, Your Honor, she could have done that. She was unaware. The respondent was handling the finances. He always handled the finances.
But the parties entered into a stipulation of settlement regarding the marital assets, correct?
Yes.
And all of this information was discoverable prior to the stipulation of settlement, right?
It should have been, yes.
Thank
There
you,
were no
Counsel. You have time on rebuttal, or did you want to finish the thought? Go ahead.
There were no canceled checks at all that were provided. There was no proof at all provided by the respondent as to what had actually been received, or when it had been received, or whether it had not been received.
Thank you, Counsel. You have time on rebuttal.
So I did have two other points, but I believe that the
You
panel
can
has
reach
read.
them on rebuttal. Thank you.
Thank you.
Good morning, Your Honors. I apologize for my scratchy voice. James Delicio, Shemtab Moss, Foreman and Beta for Respondent Dong T. Fan.
What is the proof that these proceeds were deposited into the marital accounts?
Well, first of all, Your Honor, the proof is that the appellant received in discovery a letter from AIG stating that all $640,000 of the insurance proceeds had been paid. As
This letter was received before the parties entered into the stipulation of settlement?
all the funds were received years prior to parties entering into the stipulation of settlement, and all but the approximately $89,000 payment made in July of 2018.
My question was about the
prior to
letter.
date of commencement.
My question was about the letter. Did the respondent receive the letter?
The respondent received the letter in a document production in the fall of 2018. Furthermore, as appellant received the letter in the production in the fall of 2018. But this is somewhat irrelevant to the ultimate point in this case. Appellant's own argument in their papers has nothing really to do ultimately with what may or may not have been discoverable or what may or may not have happened prior to the execution of the settlement agreement.
Counselor, if I may, the settlement agreement was executed about, 2 years after the insurance proceeds were received?
That's correct, Your Honor. The settlement agreement was executed in November of 2020.
And this settlement agreement was quite detailed, I mean, over 70 pages.
That's correct, Your Honor.
And certainly no mention of the insurance proceeds in that agreement.
That's correct, Your Honor, just as there is no mention of any other income or assets received during the marriage that existed already in marital accounts.
And you know what? Why don't you finish that sentence, because I have a follow-up for you, but you can finish that sentence.
That was my finish.
Okay, and also, in this agreement, I believe there was some type of provision that appellant had waived the right to further disclosure.
That's correct, Your Honor. The appellant represented that the information that she had received in connection with the divorce proceeding was sufficient, and that she thus waived any further discovery on any of the issues, including, of course, the issue of the distribution of the proceeds. And if I may just say that her central argument, appellant's central argument in this case, is that the interpretation of the agreement is such whereby the court found that respondent contributed these so-called insurance proceeds sometime after the agreement was executed, and that the lower court gave the respondent a credit for these distributed proceeds. None of those things happened. The predicate for appellant's central argument are things that did not occur.
Should we be concerned about the discrepancy in the total amount that was received allegedly into the bank accounts that's less than the amount represented to be what the insurance proceeds were?
No, Your Honor. So the papers set forth exactly the distribution of the proceeds. About $520,000 of those proceeds were deposited into marital accounts. Some of those proceeds were paid directly to certain providers that provided services in connection with the apartment when it suffered the damage. That's all set forth clearly in the papers themselves.
Thank you, counsel.
Thank you, Your Honors.
Your Honor. Just briefly, we've never received any of the proof that they claim they provided. You would think that when we challenged the insurance proceeds, they would have said, here's what we provided.
But the settlement agreement was entered into years after the insurance company had already paid.
Yes, Your Honor, but.
So what happened? You know, how could you enter into a settlement agreement, and if you think that you're owed money, you leave that item out of the settlement agreement?
Your Honor, I think that it was left out deliberately.
By whom? I mean, I suppose that your client was represented by an attorney, and so was the respondent's client. So who could have deliberately left that out?
Your Honor, it seems, what respondent is seeking is credit for a contribution made by a third party, no matter when it occurred. Those proceeds from the insurance company were used for the renovations of the apartment. There were carve-outs, right, with respect to contributions by the husband, and those included payments that respondent had made on account of assessments in the past and prospectively, and also loans that the wife might make toward the renovations because he would have to repay her. So it seems to.
Did she have an opportunity to discuss all this before she signed the settlement agreement? She could have investigated that.
Yes, but she was the party who was not responsible for the finances. respondent was.
But your client knew that there was a fire, knew that there was this insurance proceeds which were going to be related to the fire, and in the settlement agreement, waived any further discovery after signing that settlement agreement.
That is true.
Okay.
That is true.
Okay.
Thank you.
Thank you, counsel. Thank you both. Yes, okay. That's right. Was counsel here for Brandon Smith?
It's submitted.
It was submitted. Okay, thank you. Okay, People v. Christopher Landa. Please.
Good morning, and may it please the court. My name is Ji Hyun-rim with the Legal Aid Society on behalf of appellant Mr. Christopher Landa. Mr. Landa swiftly took complete responsibility for his actions. He cooperated with the authorities and explicitly apologized, showing sincere—
Counsel, before we talk about that, let's talk about the waiver here. What is your contention regarding your client having waived his rights to appeal?
Well, first, Mr. Landa's waiver of his right to appeal doesn't bar this court from reducing his sentence because it wasn't voluntary, intelligent, or knowing. Here, the plea court sort of critically failed to distinguish Mr. Landa's appellate rights with his trial rights. On page 6 and 7 of the plea minutes, it shows that it sort of suggests that the right to appeal would only exist should Mr. Landa go to trial, and this court has previously found in Williams, a 2009 case, that that's enough to render an appeal waiver invalid. The court also didn't tell Mr. Landa that he had a right to appellate counsel.
But on page 7, she also says you do retain certain appellate rights, correct?
Towards the end, I believe so. But in the beginning, he says, you understand that what you're giving up is a generalized right to appeal. Had you chosen to go to trial and convicted, ordinarily you can contest. And that's suggesting an absolute bar to appeal. And the appeal waiver
How
in
does
this
that suggest an absolute bar to appeal?
because when you're saying, because he begins with, you are giving up a generalized right to appeal by signing this appeal waiver, and that sort of suggests an absolute bar to appeal. And for a layperson like Mr. Landa, this would have been confusing. I'd also like to point out that respondent doesn't argue the appeal waiver point and concedes this argument, so even respondent sees that there's something wrong with the appeal waiver in this case. Going back to the merits, Mr. Landa—
Well, let's talk about the merits, right? What was the time that your client received?
he got 6 and 5, Your Honor.
Okay, and how many guns were recovered from his apartment?
There were several guns, and it wasn't— and
Several as in 4?
Yes, there were 4 guns,
Okay.
Your Honor.
And quite a bit of drugs were recovered, right?
correct,
A
Your
large
Honor.
quantity.
That's correct, Your Honor.
Okay.
And we're not trying to undermine the seriousness of the crime, but I'd also like to remind Your Honors that the court and the prosecution found it appropriate to accept the plea that he did, which was for criminal possession of drugs in the 2nd degree, where the maximum for that sentence is 10 years. And so the question today isn't about all these potential crimes he could have been convicted of. The question today is whether 6 years, where the maximum is 10,
Well, a part
is
of the
appropriate
question
in
is
this
whether, in
case.
fact, he's already gotten a good deal for what he was charged with and what he was found to be in possession of.
We're not contesting all the potential things that could have happened. What we're trying to figure out is whether 6 years is appropriate and just in the light of Mr. Landa's rehabilitative potential. The fact that he's really been in docks for, like, during a very extraordinary time where he's been confined in sort of extreme conditions, even for dock standards. He's been confined to a cell for days on end without any rec time, without any programming. His wife has been raising their baby, who was just a few months old at the time.
I'm glad you bring that up because, you know, as my colleague said, 4 firearms, a large amount of drugs. And at the time, the wife and the baby were in the residence. So that's certainly putting his family in danger.
And for that, Mr. Landa has expressed sincere remorse, and since then, he's about halfway through his sentence. He's now had the benefit of hindsight and reflection, and since if I may finish my thought, and since he's been incarcerated, he's really been focused on bettering himself. At this point, I believe recently he made the dean's list because he's been taking more courses while upstate before all of the docks wildcat strikes have happened, and he's really been staying out of trouble, Your Honors. And for someone like Mr. Landa, who's shown sincere remorse for a crime where, although dangerous, there were no allegations of violence involved. We'll have
You do a good job in your brief describing that, but you have time in rebuttal.
Thank you.
Thank you.
Good morning.
Counsel.
May it please the court, Assistant District Attorney Max Bernstein.
Do you concede the waiver issue?
We don't concede the waiver issue, Your Honor. We would concede that there was a sort of mushing together a little bit of the explanation of the trial and appellate.
Mushing together?
There was a discussion, the presiding judge did say one thing that might have loosely suggested, which this court has, counsel rightly said is sometimes a problem, suggested that the trial rights and appellate rights went together. Now, as Your Honors point out, there was a subsequent clarification of that. There was also a written waiver, which they discussed with counsel. But I think at the end of the day, the substantive claim here of a reduction of sentence just is very weak. And as a consequence of that, I don't think Your Honors have to reach the question of the waiver. On the face of it, this is a totally conventional plea bargain case. The question
If
here.
you'd gone to trial and you'd pursued the people, and you said you would have pursued the top count, that would have had an 8-year minimum, is that right?
8-year minimum on the drug count, Your Honor. But in addition, as Your Honors have pointed out, there were several gun charges, which this court has held sentences can be run consecutively on. So the overall exposure was very high. And I think it was up to 35 years. And I would just point out that, to be sure, Mr. Landa accepted responsibility in the sense that he pled guilty. But if you look at the underlying facts of this case, that wasn't exactly a great act of magnanimity. He was alone in his home with his partner and his child, and more than a pound of cocaine, a half dozen other drugs, 4 guns, 2 of which were loaded. One was a 12-gauge shotgun.
And this was his second felony conviction, right?
It was.
And there were a lot of expired OPs.
There were. And he really had no choice but to plead guilty. When he was given an opportunity, frankly, it was a blessing to not have to go to trial on the charges here. As he was manifestly guilty, there was really no plausible defense he could have raised short of, pointing the finger at his own family, which I think probably wasn't a very likely option. So the opportunity to plead down and avoid the minimum sentence of 8 years, or far worse, was a significant benefit. And there's really no reason at all for this court to revisit that benefit here. If Your Honors have no further questions, I'll rest on our briefs.
Thank you, counsel.
Thank you.
Just to quickly address the appeal waiver issue again, in People v. Gruden, the Court of Appeals says that if the prosecution doesn't respond, they're forfeiting sort of that opportunity to contest it. And
Counsel, should we consider what the maximum exposure to your client would have been had he not been provided with this offer from the people?
No, Your Honor. The court and the prosecution at the time found it appropriate to accept the plea deal that he did. And so the universe that we're sort of operating in right now is where the maximum exposure is for criminal possession of a controlled substance in the 2nd degree.
So so we should only consider what his exposure should be after he pled guilty?
Yes, that's right, Your Honor. That's our position. And again, I just want to emphasize how really extraordinary, terrible the circumstances at docks have been.
But he already got the benefit of a deal, of a plea bargain, because they reduced the charges where he faced an exposure of 35 years. They reduced it, and they, in essence, offered him only 6. So that's a major, major reduction.
Yes, Your Honor, but
So why should we reduce it even more?
Well, this court is empowered to consider all the facts before the sentencing court again, and we just want to highlight the rehabilitative potential that Mr. Landa has demonstrated here. He's maintained a job as a delivery driver for years, and he was such an excellent employee that his employers offered him his job back, and that's very rare. And that offer still stands, and it's more likely to stand in 3 years than in 6. His baby is now 2 years old, and he's going to be missing out on significant milestones. We just want to emphasize that while punishment is a component of this, and this is a serious crime, it's only one component of it, and we would like to ask the court to consider that when exercising its interest of justice powers in this case. Thank you.
Thank you, counsel. Thank you both. Mount Holly Insurance Company versus Michelle Kuo Corp.
Good morning, Your Honors. May it please the court. My name is Elliot Greenberg, and I'm from the law firm of McGivney, Kluger, Clark, and Toshia. I'm counsel for the Appellate Argonaut Insurance Company, a subrogate of 160 Bleecker Street Owners, Inc. I respectfully submit that the decision of the court below, which denied insurance coverage to Michelle Kuo Corporation, be reversed in all respects. The court below erred in deeming that the work that was performed by Michelle Kuo Corp did not fall within the scope of interior tile, which is...
So, counsel, we're talking about an exception to an exclusion in the insurance policy, right?
I don't think that it was an exception to the exclusion, because what the policy does state is that the insurance is that that Michelle Kuo Corp was insured for work that was performed with its own labor, but it carved out 4 exceptions. It said interior carpentry, interior tile, and carpentry.
So that provision that you just mentioned is an exclusion, right? The first provision.
The first provision is an exclusion, yes.
And then the carve-outs are exceptions to that exclusion.
I don't think they are carve-outs to the exclusion. I think that is the coverage is for interior tile, and the court below said that the issue was whether or not it was interior tile. When we deal with exceptions to exclusions, you're usually dealing with issues relating to ensuing loss.
Counsel, I got a slightly different question, which is, you know that your opponents say that the scope of work was actually to fill in this hole, not to put tile over the metal grating. And wouldn't that take it out of if he wasn't doing the work he was supposed to be doing, how could it be interior tile or interior carpentry? In other words, he was supposed to fill in the hole. He didn't.
That was between, that issue is between the owner and the contractor. And with respect to the hole in question, when they were there that day, there was a floorboard, which was a steel plate, which was loose. He was there to do the tile.
And we saw the pictures, we know.
Yeah. And his intention was to tile over it, and agreed. Was he supposed to remove that and fill it? Yes. But that's not what happened here. That's not what happened. And I could tell you for sure that if this happened, and let's assume the insurance policy was different, and coverage says we only cover you for demolition, and he was doing exactly what he was doing, there is no way this would be coverage, because there is no way what he was doing was demolishing, removing anything, or destroying anything. All he was doing was securing a loose floor plate, which was made of metal, which is no different than had it been a wood floor and the tile contractor just nailed it down. And the truth of what he did was all he was doing was securing it by putting a few pieces of metal, a few metal rods. He intended. Yes.
But he was welding, so using a torch, a fire torch, so is that part of tile work?
I think that's a great question. So he was using a torch to fasten a nut to a bolt. He was not using, this was not an issue where he was doing any structural welding. His intention was to install bolts into the floor, line up the steel rods with the bolts, and put a nut over it. Some of the rods lined up, some of them did not. And the couple that he did, he happened to have a tack solder welding machine and just tacked some solder to the rod, to the bolt, and that's how we fixed it.
Counsel, wouldn't you contend that that was preparation work to do the interior tiling? Is that not a part of your argument?
My argument is that was preparation work, preparatory work.
Now, I'm glad you brought that up.
Yes.
Because, you know, obviously interior tile work, it's not defined, you know, in the contract. But, you know, going from what my colleague is saying, let's say we agree with you that, you know, it is part of the work. I'm just curious, how did the other side refute that, you know, to say, no, the interior tiling, doesn't require preparation? What did they put in to contradict that?
Thank you, Your Honor. What they did was they introduced the affidavit of a tile contractor who said, I would not have done that. I would have, if I saw a loose floorboard, I would step back as a tile contractor and not do that as part of my preparatory work.
Is that something that is normally done in the industry?
That's what we contend. That's what Michael Quao said was standard for what he expected as a businessman who was on this job. It was his understanding that fixing a loose floorboard such as this, which was a steel plate, stabilizing it is preparatory work that the tile contractor would do.
So before you put down the tile, you have to prepare the surface.
Correct.
And part of preparing the surface is making sure that anything in the way is secured, properly secured.
That's correct,
And
Your Honor.
smoothed out.
That's correct.
And this is what this gentleman was trying to accomplish when he was soldering that loose plate?
That's exactly right, Your Honor.
But counsel, on the other point, Mr. Chong was the name of that worker, right? He'd never done this before, correct? He'd never done this sort of soldering to secure a floorboard. Please, you can answer the question.
Well, he wasn't used. Yes, Your Honor. This is not something that he was usually doing. His intention was merely to affix a steel rod to a bolt. The bolt didn't line up. Rather than trying to drill a new hole, he did a shortcut. And
I'm just saying he hadn't done that before.
No. But what he was doing was trying to affix a steel rod to a bolt.
Okay, thank you. You have time.
Thank you very much, Your Honor.
Good morning, Your Honors. May it please the Court. Judy Liu, Robinson & Cole on behalf of the other appellant, Sentinel Insurance Company. Your Honors, I just wanted to address the exception question from earlier. The items that are listed in the exclusion that are not precluded from coverage, including interior tile work, those are not exceptions because those items are scopes of work that the exclusion identifies in a schedule defining what the ongoing operations are that are precluded by the exclusion itself. They merely define what the insured's own labor is.
Right, but even if we say that what we're talking about is an exception to an exclusion, wouldn't we have to construe that broadly to find coverage? So doesn't that work in favor of your argument?
Yes, Your Honor. Our argument is.
So why are you fighting so hard to say that it's not an exception to an exclusion?
Well, Your Honor, first of all, the lower court was correct in putting the burden on Mount Holly, in that the insurer had the burden. Unfortunately, the lower court was wrong in finding that the insurer had met that burden, but our contention is that they had the burden and that it's not an exception. Even if it is, it's ambiguous, and the term should be construed in favor of coverage, Your Honor. Interior tile is not a defined term in the policy. The lower court incorrectly looks to the dictionary for the definition of the word interior and tile, and comes to the conclusion that it's merely the placement of tiles on a surface. But interior tile.
Your argument is that it's an ambiguous term, and therefore you should look to extrinsic evidence, but not the dictionary, basically, right?
Yes, Your Honor. At the very least, it's not defined. It's subject to more than one reasonable interpretation as the parties have put forth. And based on that alone, in the Seaboard case from the Court of Appeals and other cases that hold the same, when faced with two reasonable interpretations, the court must find for coverage as there is an ambiguity.
I want to clarify one thing, though. I think, I can't remember if it was you or your cohort from Argonaut, said that the fact that there was no hot works exclusion in the contract gives some heads up that you guys should prevail here. But did you make that argument below, or did anybody make that argument below?
Your Honor, I believe that argument may have been made by Argonaut at oral argument below, so it was made.
An oral argument. Was it in the papers? If you know.
I don't.
Oh, I can ask Argonaut. That's fine. Please continue.
So, Your Honor, in addition, the court incorrectly considered the means and methods when deciding whether or not it felt the term, whether or not the welding work was a reasonable part of interior tile work. And in considering the means and methods of the work, it really broadened the scope of the exclusion instead of construing it strictly and narrowly as it was required to do. It also, in considering means and methods, it construed the term contrary to the reasonable expectations of the parties at the time of contracting. At the time they entered into the policy, they could only understand and ascertain what the scopes of work MKC, Michelle Quo Corp, were going to perform and agree to which scopes of work would be covered and not covered. They could not have foreseen whether someone would be using a welding torch, or how someone would do the particular scopes of work. And that was improper, an improper consideration that also produces a commercially unreasonable result, Your Honor. It renders coverage essentially illusory because the purpose of the general liability policy is to provide coverage for this very instance, where the
Well,
contractor—
does it render it illusory, or does it render it to be an exclusion to coverage?
Our position is that it renders it to be illusory, Your Honor. For example, if the contractor uses the welding torch to lay down the tiles, the court would say, the lower court, based on their rationale, would say that they did the tiling wrong and that's why it's not covered. But that's the precise purpose of the policy, to cover the contractor when it does the work incorrectly, and that's what happened here. Your Honor, in addition, considering the means and methods was incorrect because it also is at odds with the exclusion's use of the term arising out of. It precludes property damage arising out of the ongoing operations that were listed in the schedule. And arising out of, the Court of Appeals has said, only requires that it be incident to having connection with having some causal relationship between the injury and the risk for which coverage is provided. And at the very least, Your Honor—
You point out in your brief that leveling, the parties don't dispute that leveling is necessary for tile work. Everybody agrees on that, correct? Didn't you say that in your brief?
Yes, Judge. I believe the lower court also recognized that. I think the experts dispute what is appropriate in terms of leveling and securing, but there's no dispute that a tile contractor is required to level and secure a subfloor.
Thank you, counsel. Is there anything else you wish to say? You
No,
have time to rebuttal as well.
Morning. May it please the court, Timothy Delahunt for Appellant Mount Holly Insurance Company.
So you have an undefined term, counsel, which is not necessarily, that doesn't necessarily mean that it's ambiguous, but you've heard them say that it was an ambiguous term, so you have to look to extrinsic evidence. What do you think about that?
It's incorrect. Counsel said that the court below erred in looking to the dictionary. Well, the cases are legion that when applying in a term in an insurance policy that the court not only may look to the dictionary, but must look to the dictionary.
But the courts also say that work in preparation to whatever that actual insured coverage is a part of the work that should be covered, right?
The argument that this was preparatory work.
Yes.
So as DOB set forth in the violation, the plans were to remove and fill this iron hatch, okay? And MKC made the decision to, instead of doing that, to weld it down. That decision.
That decision to weld it down was all part and parcel of preparing to do the interior floor tiling, right?
Maybe, but it was also preparatory for a lot of things. The
Well, what were they hired to do?
MKC,
Yeah.
they were the general contractor for this build-out. And their policy has an exclusion for their own labor. So what that means is, if they want to be, they can do whatever they want, but if they want to be covered, they have to do this work through subcontractors with exceptions. One
Right.
exception
The
being-
exclusions are strictly construed against you as the insurer, correct?
Sure, but it's not boundless. They have to be interpreted and given their meaning and their effect. And so the decision by MKC to weld instead of what they were supposed to do under the plans was I guess their prerogative. But that decision to weld instead of demolish and fill did not transform this into tiling. That's really, the court needn't go no further than that. A decision to weld instead of demolish does not make something tiling.
But that decision, you can't divorce that decision from the actual work that they were performing, which was to level the floor in order to place the interior tiling.
Mr. Chong wasn't even leveling the floor when the fire happened. Even if leveling the floor is part and parcel of tiling, he wasn't leveling the floor. He was welding a hatch instead of demolishing it. The subrogating carriers, when they brought their complaint and made their claim letters, did not, they investigated. They were on the scene. They never said this was tiling work. That came about when there was the realization that the company that started the fire was not covered for demolition work or welding work in lieu of demolition, as I say in the brief. And with respect to maxims of policy interpretation and ambiguity and extrinsic evidence, as I cited in the brief, extrinsic evidence cannot be used to create an ambiguity in a contract, in an insurance policy. If the policy itself is ambiguous, then the court can look to extrinsic
We
evidence.
all agree with that principle.
I'm sorry?
We all agree with that principle,
Yes.
counsel. You
Right.
don't have to reiterate that. Yeah.
Right.
But is interior tiling, the parameters of that work defined in the insurance policy?
There's no dispute it's an undefined term, but it's a simple term, as Justice Hagler properly concluded.
It's a simple term that also requires preparatory work.
Correct. There's no dispute that leveling a floor is proper part of tiling. The question is, what was Mr. Chong doing at the time of the fire? And he was not leveling a floor for tiling. That is pouring a tiling product to level the floor.
But if he has to first secure that hatch before he proceeds then to level the floor, isn't that all one and the same work, labor?
Your Honor, it is not, because that hatch had to be dealt with regardless of what was going to happen to that floor. If it was a poured concrete floor, if it was an iron and
Right, but
glass
what
floor,
was
it still
to
had to.
happen to the floor was interior tiling, and the interior tiling could not happen with that hatch open the way that it was.
Nothing could happen with that hatch. The hatch had to be removed and filled. That was the plan. So like I said a moment ago, regardless of what was going to happen in that restroom next or later or in 2 weeks, that hatch had to be dealt with. And MKC, as I said a moment ago, it could have had a poured concrete floor, it could have had an iron and glass floor. It didn't have to be interior tiling, but that hatch had to be dealt with. So this is a post hoc argument with boundless argument on the facts to create coverage. The policy is not a policing policy. It's not prescriptive. MKC can do its work however it sees fit, but that doesn't mean it's covered. Implicitly, what MKC was supposed to do was follow the plans, and if it wanted coverage, hire a demolition subcontractor to take that hatch out, and then hire a concrete
Where in the coverage
subcontractor
does
to
it say
fill it.
that?
What's that?
Where in your
It
insurance
doesn't.
policy
It doesn't.
does it say that?
It doesn't. That's why I said it's not, the policy doesn't prescribe what they were supposed to do, but what they did is not covered. Thank you.
Thank you, counsel.
Thank you, Your Honor. I just want to point out that Mr. Chong, when he was on the site, when he was there, actually there to place the tile, in his transcript, he said he stepped on that plate and it was loose, and that's why he took some materials that he found on site just to secure it.
So we have evidence in the record by way of testimony as to what work was being performed, right?
Yes.
And the reason why the hatch was being filled.
The reason why it was being secured because
Secured.
it was loose.
Right.
He couldn't put the cement and the tile on.
So this idea of basically manufacturing the fact that this work that was occurring was the interior tiling doesn't bear out from the record, right?
The record is he was there and he stepped on the metal, it was loose, and he couldn't put tile on top of it because the grout and the tiles would crack. And he had to prepare that, and that was part of the interior tile preparatory work.
Were there any plans and specifications as to how to deal with this hatch in the build-out that they were performing?
There's no question that what they did, they were supposed to have removed that hatch. But what would happen on the actual site is they said, hey, I'm just going to put the tile on top of it, and I'm not going to do it. And yeah, there's no question that the plans with the owner said he was supposed to do one scope of work. They decided, I'm going to put the tile right on top. With respect to the complaint, we sued based upon the negligent use of use of hot works, and that's what caused the fire. And what he was doing, that was not alleged in the complaint, other than the negligence.
That was the first time he's ever used one, correct?
Excuse me?
That was the first time Mr. Chong used hot works?
That was his testimony. That was his testimony, yes. Yes. And you would ask a question earlier about hot works. The reason the issue of the hot works exclusion came up, that came up in oral argument before the court below when he was saying, well, the contractor was negligent in using a torch. And I said, so shouldn't we deny coverage because he failed to use the torch properly? And my response to him was, hey, the means and methods he uses to attach a nut to a piece of metal to a bolt, or he could use a nut, he can use a nail, he can use whatever means, unless it's excluded, and that's how it came up.
Thank you, Counsel.
Thank you very much, Your
for
Honor.
clarifying that.
Thank you, Your Honors. I just want to address the point quickly regarding the contention that the arguments about tiling work were made to manufacture arguments for coverage. Your Honors, the action was commenced by Mount Holly against the appellants in this case in 2021. In 2020, the building owner actually, I believe, sought coverage, tendered and sought them to pick up coverage for the building owners, and there was litigation between them in federal court. That testimony from 2020 regarding the tiling work that was being done and testimony by Chong and Kwao, that was all from 2020. And that's where we got the information that the scope of work that was being performed and the very employee that performed the work said it was tiling work, but that was back in 2020 before this action was commenced. Your Honors, additionally, I just want to emphasize that even if the lower court was correct in considering means and methods, and we do not think they were, and concluding that our expert somehow does not find that the welding was usual and customary and appropriate method, and that's why it denied our motion for summary judgment. We respectfully contend that our expert does in fact say that. He just uses different words to say that. Our expert says that the welding squarely falls within the scope of interior tile work and that the preparation of the subfloor was appropriate.
Counsel, I think you're right about that. And it didn't seem to me that the plaintiff's expert, Mr. Romenko, really grappled with that issue, I will say. So,
Yes, Your Honor.
Any other questions? I didn't mean to cut you off, Counsel. I just wanted you to know that I think you're right about that.
Thank you, Your Honors.
Okay, thank you. Thank you all.
Thank you.
Okay, Kuteller v. Mamakos.
Good morning, Your Honors. Michael Confusio for the appellant. Even accepting the judge's determination below that the defendant received notice of the case management conference, we submit it was an error to fail to reinstate her answer for a couple of reasons. The case law, if you look at the case law, it talks about evaluating what the sanction should be, and we think that the sanctions are not consistent with the case law. Length of delay, it was only a month after the order.
She'd had a prior non-appearance at a conference, though, right? On March 22, 2019. Should we factor that in as well?
I don't think so, because she had the attorney back then, and then that attorney withdrew. So to me, that's the fault of the lawyer that represented her, not her.
Should we factor in the fact of this not quite credible assertion that her address was incorrect?
Well, I think that you have to credit what the judge found, which is he rejected that. So yeah, I do think the court should credit that. But I still think this is the significant part. This is a case where the defendant filed an answer, first of all. So then you go to the function of, is it a just sanction to actually go to the ultimate sanction of striking her answer? And if you apply the factors there about length of delay, there was no prejudice shown by the plaintiff.
Well, let's talk about length of delay. Was it just one conference that she missed?
That's not, but the length of delay is, I would submit, Your Honor, is measured from the date of the order that struck her answer to the time that she moved to vacate and reinstate her answer. That was a month.
Okay, so in terms of the sanction and the factors that were to consider, the fact that she missed multiple conferences, what bucket do we put that in?
I think you put that in the bucket of, I don't really know if it fits in a specific bucket. I think the relevant finding by the judge below is that he found that she received notice of the conference that she didn't appear at. But if you look at it, a case that the defendant filed an answer in this kind of a case that involves a case hinging squarely on credibility of the parties, and frankly, a relatively serious case of defamation versus sexual harassment, that's not the kind of a case where a defendant files an answer that her answer should be struck for failing to appear at a conference.
Well, let's talk about the discretion of the trial judge when it comes to discovery matters and sanctions, right? Our review of that is what exactly?
I think it's normally an abuse of discretion, but it shouldn't be in this case, because if you look at the record below, there wasn't even a motion to strike her answer. She didn't appear at the December 2021 conference. And then there was like, the judge just said, I'm striking her answer.
Wait, 1 second, back up.
That's not exactly the case.
Okay.
Because from my memory, and I know that you'll correct me if I'm mistaken.
Sure.
I believe there was language in one of the orders that failure to appear at the December 6th conference may result in, and I'm just going to paraphrase if I may, striking the answer. So how do we factor that in, that it was written in the court order? How do we factor that in?
I think that weighs against my argument. No question.
Okay, let's go on. And then how do we factor in, as my colleague said, and I'm paraphrasing again, that, I'm not aware, it's not the wrong address, and clearly we have evidence that that was not accurate.
But Your Honor, I'm already accepting that, as I must on the record.
Okay.
But
that cuts against you as well.
But not dispositively. Because if you look at the factors, she filed an answer. This is a pleadings case. It wasn't a default where she defaulted against the complaint. And if you look at the case law talks about, this is a sanction. They say the ultimate sanction of striking a defendant's answer should only be assessed when the defendant's conduct, one, obstructed the court process, and despite the failure to appear at the conferences, the plaintiff didn't put anything on the record that shows it obstructed the process. In fact, the trial was scheduled, and that it prejudices the plaintiff. The plaintiff didn't say anything about a prejudice. And in fact, there wouldn't have been any. The trial just could have gone on, but I think the defendant should have been allowed to participate in the trial as scheduled rather than a default.
Didn't she participate in the inquest?
Only with respect to being able to cross-examination, which is a proof hearing, and it was only with regard to damages. And other than that, unless the court has questions, I would rely on my written brief, but I asked the court to reverse and remand and reinstate her answer so both parties could participate.
Thank you, counsel.
Thank you, Your Honors.
People v. Joseph Garcia.
Good morning.
May it please the court, Elizabeth Vasily, Center for Appellate Litigation, on behalf of Mr. Joseph Garcia. I also wanted to note I had two wonderful Columbia Law students, Daniel Richardson and Mohammed Kamara, assist me with this brief. The verdict was against the weight of the evidence because the facts supported Mr. Garcia's intent to temporarily use the complainant's Metro card to obtain a swipe into the station.
Well, how is it temporary when he, after the complaining witness requested it back, when it didn't work, he ran out of the train station with the card?
That's actually not the evidence, Your Honor. There's no evidence that say that he fled. Now,
Did he stay and give back the Metro card?
he didn't stay and give it back, Your Honor, but the complainant left, right? The complainant left. He left Mr. Garcia standing right where he was trying to swipe that card. So at that point, Mr. Garcia really had no ability to give it back. But there's no evidence that he fled. And instead,
There is evidence that the complainant requested his card back, and Mr. Garcia did not return the card to the complainant.
that's right, Your Honor, but that is wholly consistent with temporary use. He wanted to get that swipe. He was swiping. It's just like joyriding a car, right? Like
Now,
temporary-
isn't there also evidence that Mr. Bell, the complainant, was attempting to leave the station to retrieve his card from Mr. Garcia when Mr. Garcia pulled out or showed a weapon and in a threatening manner sort of like told the complainant to come, which caused the complainant to step back?
That's all correct, Your Honor. But that doesn't mean that he had an intent to permanently deprive the complainant of his Metro.
Why not at that moment return the card?
Because he wanted to use it right then and there, Your Honor. He wanted to keep swiping. He wanted to get into that Metro station.
So then
Okay,
we
so-
have that he's been requested, the complainant requests the card, then the complainant attempts to exit to retrieve his card, and at both instances, the defendant refuses to return the card.
That's right, Your Honor. He wanted to swipe that
And
card.
brandishes a weapon, right? Let's not forget that critical part.
The complainant says that he saw a knife. Yes, the video's a little unclear, but for the
The video seemed clear to me,
from this argument,
and it was clear to the jury.
for the purposes of this argument, Your Honor, we're not contesting that because we feel this element is not met here. That this hole is so obvious that there was no intent to permanently deprive him of his
How
Metro
is that
card.
so obvious when he brandishes a weapon to keep the complaining witness from retrieving his Metro card back?
He only wanted to temporarily use it. Give me more seconds. You know, I'm trying to swipe the card. This is
So
like
what, the
joyriding
card
a
wasn't
car.
working? Because, this happens, you repeatedly swipe it, so you're saying, oh, the Metro card isn't working, I got to keep on swiping it? Is that what happened?
That's what happened, Your Honor. And unlimited Metro cards reset every 18 minutes. He wanted to get into that station. If Mr. Garcia really wanted to permanently deprive the complainant of that card, he would have run away with that card as soon as he given it to him. Or when the complainant was going to get the card back, he would have ran away with it. He would have flashed a knife and ran away with it. But he stood there because he wanted to temporarily use the card. And there's no evidence whatsoever that he intended to permanently take this card.
Or there's testimony from the complainant and from a detective that Mr. Garcia was seen running out of the station when the complainant returned with the police.
There was no testimony that he was running out of the station. That is not an evidence, Your Honor. There's no evidence that he fled. He was no longer in the station after the complainant went to the police station, told them the story, reported the crime, came back down to canvas. By that point, 10 minutes later, we don't know. Most New Yorkers don't spend more than 5 to 10 minutes in a subway station, so it can't constitute fleeing.
So it's absolutely normal for someone to flash a knife just to temporarily use the card so they can gain entry?
It's not, Your Honor. This was wrong, but this was not larceny. This was not robbery. And Mr. Garcia got an 8-year sentence here, and I understand my light's on. I'll reserve the rest for rebuttal.
Thank you, Counsel.
Good morning, Your Honors. My name is Patricia Curran, and I represent the people on this appeal. There was evidence that the defendant fled the station. The victim gave testimony that he walked about 20 feet to the transit police station, informed the two officers, and if you look at the video, you see them coming back to the area of the turnstile, leaving through the very emergency gate that the victim tried to get through to retrieve his card, and the defendant was not there, and when they went upstairs to look for him, he wasn't there either. So he did flee with the card. In addition,
Well, your adversary says that it's just not normal for people to stay in a New York City subway station for that long. So how do we equate that to him fleeing?
I'm sorry, Your Honor, I'm not understanding.
Your adversary just made the argument that it just isn't normal for people to stay in a subway station for about 10 minutes. How do we factor that into your argument?
I'm not sure why you would. He took the card and left the station. And obviously, he did not give the card back to the victim, displayed a knife, threatened him when he tried to leave the platform through the emergency door. And by the way, the other video shows that 2 days later, the defendant was using the card in a Bronx station to help people through the turnstiles.
And we know that that was the card because the investigation was able to track the Metro card serial number using.
Yes, it's
Okay.
the MTA document.
Counsel, is that relevant to what his mens rea was at the time of the act?
I'm sorry, Your Honor.
I'm sorry. Was that, the subsequent video, how is that relevant to his mens rea at the time of the act that
Well,
gave rise to
because
this prosecution?
It shows that he had no intention of ever returning the card. If he really wanted to return the card, he would have given it back to the victim when the victim tried to come in through the emergency door. Instead, he displayed a knife.
No, but what I'm asking you is, can we use the subsequent video to somehow retroactively infer that he had the necessary mens rea at the time that he wasn't handing the card back to Mr. Bell? And if so, why?
I think you absolutely can. It shows he continued.
Maybe he had an intent. You have to show intent at the time of the actus reus, correct?
Yes, Your Honor.
Okay. So 2 days later, how does that relevant? What do you
Because it shows that at the time of the incident, at the time when he displays the knife and refuses to return the card, that he intended to permanently deprive the victim of the card and the value of the card. And he is continuing to use the value of that card 2 days later, which is additional evidence that shows to the jury that he intended to use the card for his own use. I see that my defense counsel.
You've got another minute if you want. Do you want to talk about legal insufficiency? I mean, excuse me, do you want to talk about ineffective assistance?
Or the waiver point. The defense attorneys here, he had two below, provided effective assistance of counsel here. They faced daunting evidence. The crime in this case was on the surveillance tape, and they decided a reasonable and sound strategy in trying to defend the defendant here. They decided to argue, understandably so, that the victim was mistaken in the fact that the defendant displayed the knife. And as some of you have seen the video, this show of metal is not the strongest, I would say, though it certainly corroborates the victim's testimony. And then in addition, they argued that the defendant could not have gotten through the high wheel turnstile in order to immediately show an immediate show of force. This was an entirely reasonable and sound strategy against daunting evidence. In addition, the evidence showed beyond a reasonable doubt, as I've already spoken to, that the defendant intended to permanently deprive the victim of his card. That kind of defense, as defense is now suggesting, would not have been persuasive.
Thank you, counsel.
If the court has questions about the waiver, I'd be glad to answer it. Seeing none, we rest on our brief. Thank you so much.
Briefly, the use of the card after has no bearing on his intent in the very moment that the knife was flashed. He didn't run away with the card. He didn't do anything that would have shown he wanted to permanently deprive.
He just didn't give it back, and he flashed a knife in order to keep it.
That's right, Your Honor, but that's wholly consistent with wanting to temporarily.
Just because you keep saying it doesn't make it so.
Your Honor, this is just like the joyriding cases. This is no different than joyriding a car, and there's no intent that the person intended to take the car forever as opposed to do it. This is the urban version of joyriding. As for point 2, the ineffective assistance of counsel, the attorneys argued legally irrelevant facts, and that was the lack of the immediacy of the threat when this was a retention case. And the record plainly shows that, and that was a mistake. They should have focused either on lack of permanent deprivation or something else, but instead they went on this theory that was legally irrelevant. And this is just like any other of the cases, Holland, DeBellis, the recent case Calderon, cited in my briefs, that show that on direct appeal, the record does show that they made a mistake, and they argued this at the motion for trial order dismissal in front of the judge. The judge said to them, this is different. This is a retention case. And reminded them what the law was. And despite this reminder from the judge, they continued in summation to make this argument again. And this distracted the jury, this deprived Mr. Garcia of a fair defense, arguing this lack of an element, like we argued in our point 1, would have been a more favorable defense. But either way, this defense focused on legally irrelevant facts.
Thank you.
There are no
Counsel.
further
Thank you both, and thanks also to the Columbia Law students who assisted you on the brief. Thank you. Stafford v. Naxon.
May it please the court, Michael Kazoris from the Law Office of Eric D. Feldman on behalf of the defendant's appellants. Your Honors, I'd like to address the timeliness issue first. It's our position that we showed good cause for the late filing of the cross motion for summary judgment because the parties were undergoing settlement negotiations. There was a settlement conference on September 27th, I believe, of 2024.
Counsel, let's pause right there, because I was under the impression that you didn't even raise that argument until reply, and there's case law that indicates that that's insufficient. So did you raise that initially or on reply?
I do not believe that that was raised in the initial papers on the cross motion.
So would you agree with me that there is case law that indicates that raising that for the first time in reply does not constitute good cause? Would you agree with me with that?
Well, there is case law that says that certain issues raised for the first time on reply should not be.
That wasn't a question, counsel. My exact question was that there's case law that says raising good cause on reply, that doesn't constitute, that's insufficient for good cause. That's the question.
I agree with you, Your Honor. I think we can make, if the court will allow, make an exception here because the facts of the case and in the interest of justice indicate that the parties were undergoing settlement negotiations, and when the case did not settle on the date of the settlement conference, the cross motion was made that very same day.
So the reason for your good cause is not law office failure, but instead ongoing settlement proceedings?
Correct. And Your Honors, the Smith-Barney case decided by this court indicated that failure to timely settle a judgment, quote, should have been excused in view of the ongoing settlement negotiations. I think that by analogy could serve as a basis for good cause in this case here.
Let's say if we don't agree with you, let's just say that, but
Sure.
let's, talk about, because I think there was an argument that you say that, it was timely because the issues were identical, but certainly the initial motion was on liability.
Right. Well, it's our alternative argument that we didn't need to show.
I'm not done yet. I'm almost there. I'm almost there. And then there was the cross motion for serious injury, right?
Correct.
Now, those are not identical.
Your
Are
Honor,
they? Are they identical?
I think a good argument can be made.
Okay, let's hear it.
that they are identical
But there's
because
case law that says they're not identical, right?
There's-
From this department.
there, I think you're talking about the Priester case?
Yes.
Yeah, well, the Priester case involved one party, one defendant making multiple
Successive motions, but ultimately,
judgment.
within the decision, it talks about whether in fact those two issues are identical, does it not?
It does, Your Honor.
And it says,
It says that serious injury is an issue for as to damages and is separate from liability.
separate from liability.
Separate from liability. Yeah.
But that's not the only case that says that.
I think that's the most recent case.
That's the most recent, yes.
That says
There
that.
are others.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good morning, Your Honors. Jesse Young for the respondents. I believe that this court need not reach the merits on this case. I think the law is very clear cut. The precedent from this court, this was an untimely motion. I agree with Your Honor's questioning about not raising the issue of good cause. And even if that was raised, I'm not aware of any case law under these
Should we
circumstances.
consider the fact that the lower court actually did consider the merits of the motion?
I think you could do that, but need not do that. We would argue that on the merits, the lower court made the correct decision. I would also note, however, we initially made a summary judgment motion on liability because this was a rear-end car accident. This motion was adjourned one time by STIP. There was never any mention that there was going to be a cross motion. Then 7 days before the adjourn date, the cross motion was filed. We did not have time to retain an expert, which we certainly would have done under the normal course of motion practice. But in this case, this motion was already adjourned. We don't know if the judge is going to accept another adjournment. So we were not able to even present the evidence that we wanted to. We would have had an expert report that would have had more evidence. So I think the court is free to look at the merits. I guess my opinion is I think it's simpler to just say procedurally this motion was late and it should have been denied on those grounds. They will have an opportunity at trial.
Counsel, untimeliness was preserved below, right? It was made before the court, even though the court didn't go off on that. Correct? It was argued.
Yes. Yes. Yeah, my motion papers in the court below were mostly talking about untimeliness, and all the same arguments in the brief essentially were made to the court below. And we believed it was so clear cut that was the most of the thrust of our argument below was procedurally, and the fact that we didn't have time to retain an expert and go more into the merits. Although I did argue that on the merits, that there was an issue of fact. Are there any more questions?
Thank you, counsel.
Thank you.
So counsel, before you get into your point, did you actually file leave to file a late notice?
Did we file leave?
Right, did you seek leave to file a late motion? So outside of you arguing that you had good cause to file this motion late, did you seek permission from the court to file this motion late?
No, it was not. It was late in the sense that it was beyond the 60 days after the note of issue, if that's what Your Honor is talking about. And we did not seek permission to file a motion or a cross motion after the 60 days had expired.
And aren't you required to do that?
I don't believe we are, so long as we show good cause or that the issues are nearly identical. Your Honors, I think it's so clear that there's no serious injury here that if this case goes to trial, we're going to be back here. If the trial's in plaintiff's favor, we're going to be back here post-judgment making the same arguments on the merits. I think in the interest of justice and judicial economy that the court should look at the merits of the case and dismiss the complaint. Thank you.
Thank you, counsel. Thank you both. Okay, Pichardo versus the George Units LLC.
Good morning, Your Honors. Kenneth Gorman for the plaintiff respondent. The defendants never met the burden for summary judgment in the first place with this case. The plaintiff, her sister, and Carmen Toribio, who both came to assist the plaintiff after the incident.
Counsel, just talking about Brunhilde's, that was the sister, right?
Correct.
Her EBT testimony. You cite in your brief only to where she said, yeah, I saw people mopping, but you don't cite the contrary testimony where she says, I did not see anybody mopping. And shouldn't you have, at least in candor, have told us that?
Absolutely, and I apologize for that.
How do you deal with the discrepancy then?
They all testified that the stairs were wet. And Carmen did, Brunhilde, she did testify, her sister, that after the incident, she looked at the steps and they appeared as if they were wet. And I just want to point out that Carmen Toribio testified that it appeared as if someone mopped the staircase because she smelled bleach. I want to point the court's attention to this case, Velez versus Nisha. It's at page 5 of our reply brief. And in that case, there was no direct evidence of the defendant's custodian mopping the stairs. However, this court affirmed the denial of the defendant's motion for summary judgment because the plaintiff and his uncle both testified that the wet substance on which plaintiff slipped appeared to be a cleaning agent. And in Healy versus ARP Cable, which Velez cites, the site for that case is 299 AD 2D 152, the plaintiff ascended the staircase 20 minutes before the accident without incident. However, this court reinstated his complaint because the plaintiff's co-workers testified that the stairways looked wet as if somebody had just finished mopping. I don't think the evidence in this case is just as strong as those two cases. And
counsel, the discrepancy would go to credibility or weight of the evidence, right?
absolutely, it would, yes. In addition, even though there might be a discrepancy in her testimony, the plaintiff and Carmen both testified that the stairway was wet. The plaintiff, her clothes were wet after she was lifted from the steps after the incident. The only person who had knowledge of this was Mr. Almonte, but the defendants never disclosed him as the person who was mopping, who was working on that Saturday morning. They merely disclosed the names of 3 porters, one of whom was Mr. Almonte, in their May 17, 2023 discovery response. That was served 2 months before the note of issue was filed and 13 months after plaintiff served his June 29, 2022 discovery demand.
So it was Mr. Almonte's affidavit was 2 pages, right?
2 pages, that's correct.
And the building has 32 stories, is that right?
That's right. If he was able to remember that the 10th floor was not wet in this 32-story building, then the defendant should have produced this witness for an EBT, producing Mr. Schwimmer, who had no knowledge about the conditions of the staircase, no knowledge of the lighting conditions, and then sandbagging the plaintiff with Mr. Almonte's affidavit, which was clearly tailored to dismiss plaintiff's case, was underhanded. At the very least, the plaintiff should have the opportunity to cross-examine Mr. Almonte at trial. And with regard to the lighting conditions, there was no evidence that the lighting conditions that the defendant's expert saw 3 years after the incident was the same lighting conditions that the plaintiff.
Did she fall because of the lighting, or because of the handrail, or because of the water?
It was the lighting of the water. It was the lighting of the water. I don't know about the handrail. She was holding the handrail. When she slipped, she let go. So I don't know if the handrail.
Because actually, counsel, I know the bill of particulars mentions that, there was an improper handrail, but actually the plaintiff testified that there was nothing wrong with the handrail, and certainly really just focused on the lighting and the wet condition, but there was nothing about the handrail.
Correct.
You can see that.
It wasn't up to code, but it wasn't a proximate cause of the incident, so I do have to concede that. She testified that there was nothing wrong with it, and she was holding on to it. So the whole thrust of the plaintiff's case was the lighting conditions and the water. If the court has any other questions, I'll let my have.
You have time to rebuttal as well.
Thank you.
Thank you, counsel.
Morning, may it please the court, Allison Snyder from Marshall Dennehy for the defendant respondent. As we indicated in our brief, the plaintiff's failure to confront the Brunhilde Pichardo's recantation of her testimony that she saw two men mopping the floor immediately before the accident.
Counsel, plaintiff herself did testify it was wet, quote, like they mopped it and left it wet, close quote. So does that give rise to an issue of tribal fact?
Not at all. The plaintiffs concede in their brief that this isn't a notice case, that they're solely proceeding.
Well, it's a cause and create case, so could that not be evidence of cause and create?
Right, but when it comes to any evidence that the defendants actually created the condition, this is different from the case that the Velez that plaintiff's counsel referred to. In that case, there was only the evidence was that it appeared to be a cleaning agent that was the source of the condition.
Here, didn't a witness say that she smelled Clorox?
Well, she said it could have been that or it could have been urine. And this is something that she testified to years after she provided an affidavit in which she made no mention of smelling bleach. So this is something that appears to be a little bit like a game of telephone, I think.
Speaking of games, why was Mr. Almonte, why did his name come up so late in the process?
I don't have any basis for or I don't have any knowledge as to the circumstances of that, but it's conceded by the plaintiff that his name was disclosed months before the note of issue. They never sought to, there's certainly nothing in the record that they sought his deposition, so they were apparently fine with the affidavit alone.
Why would they seek his deposition if they have no information about what he was going to say until it was placed in papers?
He was disclosed as a witness. So that's apparently they decided to roll the dice, and what they're left with is testimony from a superintendent. And contrary to in the brief, they argue that his affidavit relied solely upon custom and practice. That's not the case. He testified that he did a walkthrough of this particular stairway and did not observe this wet condition. And he also said that he was the sole porter. That's not in dispute. So any evidence that it would have been created by two workers is purely speculative. The mere presence of a wet condition alone is not enough. It could have, for all we know, there could have been another tenant who was on the way to the laundry room and they spilled whatever they were using for their for their laundry. And in that situation, it's a transient condition. We're not going to be liable for it. And you certainly can't say that it was something that was created by the building. The entire argument is speculative. And as we indicated in our brief, the plaintiff's refusal to actually confront this recanted testimony, it's not just a frivolous argument. The whole argument about creation of the defective condition obviously falls apart if you actually give consideration to it. The fact is that the trial court below made a factual finding that the plaintiff could not come forward with admissible evidence that this was a condition that was created by the building. And they specifically referred to Brunhilde Pichardo's testimony that she did not see anyone mopping. And in this situation, the plaintiff's failure to actually raise a dispositive factual finding by the trial court precludes them from the court reviewing this.
Thank you, counsel.
Thank you.
We understand your argument. Thank you.
With regard to the disclosure of Mr. Almonte, I want to refer the court to page 1037 of the record. They disclosed 3 witnesses. Mr. Almonte was one of them. They never disclosed that Mr. Almonte was working on that day, or the other witnesses for that matter. We don't know what they were doing because they just listed 3 witnesses and nothing else. Mr. Almonte should have been disclosed earlier, and this whole case hinges on his affidavit. Without his affidavit, they don't have summary judgment. Thank you very much. If the court has no further questions, thank you.
Thank you. Thank you both. McLeod v. New York City Health and Hospitals.
Good morning, Your Honors. Jillian Rosen for the plaintiff appellant. The trial court erred in dismissing this complaint on January 12th, 2022. Let me take you back to the June 18th, 20 order, which is at 33 of the record, because that really sets the stage of the errors here. So on this date, the court granted plaintiff's motion to deem the late notice of claims.
But the question is, of course, was that conditioned on serving the defendants within 30 days with a notice of claim?
Two things. I don't think it was conditioned because they deemed it timely served. They deemed it timely served nunc pro tunc, meaning what was done then is proper now. So in that regard, I don't believe that there was anything that had to be redone. And certainly the
Except for what the court directed the parties to do.
Okay, I understand, Your Honor, and it's not conditional. It's interesting, if you look at the order, it doesn't look like it's a conditional provision. It just says, within 30 days of the date, movement shall. If you look at 33, it does say that that they're granting the motion as follows, as opposed to it being conditional. But let's say it's conditional. So the first part of this is, I think what nunc pro tunc did, what it does, is says, I am now taking this late notice of claim and I'm rendering it valid now. Let's take the other scenario like you posed. Let's say it's conditional. If it's conditional, our position is that the 30 days that was instructed on June 18th, 2020, that the plaintiff complied, and here's why. It's the COVID toll. So on June 18th, 2020, we're in the midst of the pandemic, and if you take the date of June 18th, 2020, and you calculate what's left until November 3rd of 2020, which is when the toll was lifted, it's 138 days. How you calculate the toll under Brash is you take the 138 days and then you add it on to November 3rd. That takes you to March 22nd, 2021. What did the plaintiff do? Before March 22nd, 2021, February, which is at 138 to 143 of the record, the plaintiff reserved
The notice of claim on that date.
Right. So, and it was received on February 25th. So if we're to look at that, Your Honor, as a conditional order, our position is the COVID toll extends that time. Plaintiff satisfied it within the COVID toll extension. And what's really significant here, and if I run out, I could take it on reply, but what's very significant here is that in the June 18th, 2020 order, the court found that actual notice was established and that there's no prejudice. In fact, the court actually said at 36 of the record that the defendant didn't even raise an issue of fact with regard to, and did not provide any particularized evidence under Newcomb to even dispute the fact that there was no prejudice. So here we have a case where it's established that there's no, that under the factors of the notice of claim and under public policy, that it should be heard on the merits and the client shouldn't suffer for any delay. But here we don't even have the delay given the COVID toll. So that's why the order on January 12th, and what also is faulty about the order of January 12th, is the order of January 12th, if you look at 6 of the record, the court seems to conflate what plaintiff is doing. Plaintiff is not asking never asked to refile or to make a motion for a late notice of claim. So it says on 6, I can't extend the statute of limitations for you because it passed. We didn't ask for that. You already on June 18th, 2020 said that our notice of claim is deemed timely nunc pro tunc. So that's not what we asked for.
Ms. Rosen, let's say we don't agree with you. Would you agree that a court does not have discretion to grant leave to file a late notice of claim past the expiration of the statute of limitations? We can agree on that.
Yes.
Okay.
We can agree on that, but Your Honor, what I think, but that's not what we asked for.
Oh, I know.
Yes, absolutely, absolutely. The cases are legion on that, and that's why, given the COVID toll and the fact that we actually served it within, if you look at the COVID toll, we served it within that time. The statute of limitations was protected, and I could take it up on reply.
Okay.
Okay. Thank you.
Good morning, Your Honors, and may it please the court, Lauren O'Brien on behalf of the New York City Health and Hospitals. This court can resolve this appeal based on a very straightforward application of the statute of limitations. Even taking into account the relevant tolls, including the COVID tolls, the limitations period expired on November 9th, 2020, and McLeod failed to bring her motion until some 6 months after that deadline. McLeod relies heavily on Supreme Court's earlier order granting her more time to serve her late notice of claim.
What's different about your calculation of the tolling period from your adversary's calculation?
Frankly, I don't quite understand my adversary's calculation of the tolling period. I think it's clear there were 6 days left of the statute of limitations when the toll began. The toll ended on November 3rd. That's undisputed. And so under Brash, which is the case that she cites, but also under all of the cases on this issue, the statute of limitations just begins where it left off on November 3rd.
It doesn't add additional days, right?
Right. I think my adversary's position is that the court should count the number of the tolled days twice, and there's just no support for that position. And nothing in the executive orders or in the cases she cites supports that theory. It's clear that the statute of limitations is just suspended at the start of the toll, and then it continues where it left off here 6 more days at the end of the toll, and that it would have been done on November 9th. And even taking my adversary's argument that, well, we still had the 30 days that the court granted in its order, if you count that from November 3rd, that only gets you to the beginning of December, and no actions were taken by then. So any notice of claim that McLeod attempted to file after that were barred by the statute.
The temporary suspension ended on November 3rd, then the clock started ticking again, and there were 6 days on the clock. Is that right?
That's correct, Your Honor. So unless Your Honors have any further questions about that, and then I just do want to be clear that the order, the first order that instructed McLeod to file and serve the notice of claim, it's clear that that had to be done within 30 days.
What in the order leads to your argument that it was a conditional order, that it wasn't a deeming of it being filed timely nunc-pro-tunc?
So the mention of the motion being timely served nunc-pro-tunc, that was just sort of a description of what the motion was. Immediately following that description, the court says the motion is granted as follows, and then it says that the notice of claim must be served and filed within 30 days of this order. So unless Your Honors have any further questions on that, I just want to briefly also say that as for the second and third orders appealed from, the first is in substance a ruling on a motion to re-argue, which is not an appealable order, so this court should dismiss that appeal. And then the third was abandoned in the opening brief, which does not discuss the res judicata grounds on which the case was dismissed. And even on the merits, under matter of Hunter, all you need is a judgment on the merits between the same parties involving the same subject matter, which is what we have here. So unless Your Honors have any further questions, we ask this court to affirm. Thank you.
So I think where the 9 days comes from, I think here's why that's erroneous, respectfully. I think that the 9 days is, I'm sorry, the 6 days that takes you to November 9th is erroneous because that would apply if we had never made a motion to deem the notice of claim timely served, and if the court had never deemed it timely filed nunc-pro-tunc. That's where the 9 days, or the 6 days would come in to take you to November 9th. What we have here is we have in the June order, we have that the court said your late notice of claim from February is deemed timely served nunc-pro-tunc, and you're just going to have to refile and reserve, which actually seems to be inconsistent because it's already deemed nunc-pro-tunc. So it seems like a ministerial act. So then the 6 days isn't applicable here.
There's nothing ministerial about filing a notice of claim. Isn't that a condition precedent to the lawsuit?
It is, and it's ministerial because it's refiling and reserving, because what we did originally was—
The adversary said that that was just a description of the motion in the order, not what the actual order was.
I'm sorry, I don't understand that. Oh, no, okay, my position is that what the court did was deeming it non-pro-tunc is saying what you did was what you did then that was timely is now in effect now. So the 6 days would apply had the plaintiff never filed a motion for a late notice of claim, which was already granted. So that's where I think that the 6 days is erroneous in the calculation. With regard to the second order, it's not abandoned, or whatever my adversary said it was. This was a motion to renew, and renewal is always appealable, as you know, and it dealt with the COVID toll, and it dealt with the law office failure regarding the COVID toll, so it's most certainly in front of this court. With regard to the third order, just really quickly, it could be superfluous, but what the third order does is that if this court renders the January 12th, 2022 order not on the merits because it was erroneous, then 205A most certainly applies, and plaintiff's second commenced action would be valid.
Okay, thank you, counsel.
If you have no further questions, I'll rest on my brief.
Thank you very much.
Thank you.
both. Finally, HSBC Bank v. Nicholas. Okay, counsel.
May it please the court, my name is Kathleen Massimo, and I represent Appellant. Appellant here respectfully requests that this court reverse the lower court's order. The lower court's ruling rests on two fundamental errors. First, a misreading of the law governing the parties' 2011 stipulation to discontinue the prior foreclosure, which told the statute of limitations, rendering the current foreclosure action timely, and an improper retroactive application of FAPA. Here, the parties entered into a written stipulation filed in a 2008 foreclosure to discontinue and agreeing that the statute of limitations for any claim of plaintiff or defendant against the other is
Right,
told.
so you had a bilateral agreement.
Yes.
But does FAPA have a presumption that there's an imbalance of negotiating power between lenders and borrowers? And therefore, should we discount the fact that it's bilateral?
Your Honor, I don't think so here, because here we had two parties who were represented by counsel. So the borrower here, not the borrower, the estate here, was represented by counsel. And he also had in here that his claims were told for a 5-year period, which he took advantage, or she took advantage of when she filed suit and asserted certain affirmative defenses and claims. So here, I do not think that that's the case. The trial court essentially took issue with the fact that because it was not signed by respondent personally, but respondent's counsel, that it lacked because it lacked the express promise to pay, despite the law requiring either conditions to toll the statute of limitations here. So here, CPLR 2104 allows parties' counsel to agree. So here, there shouldn't have been an issue as to who exactly signed the stipulation that was filed in court. CPLR 2104 also allows the parties to agree to a tolling of the statute of limitations, which is exactly what occurred here. In addition, the tolling agreement is enforceable regardless of whether FAPA applies retroactively or not.
We've held such. I know you'd prefer we had not held such, but
yes, Your Honor.
And that's before the Court of Appeals, or aspects of it.
Yes, it is, Your Honors. I'm well aware of your stated position and my position in light of that fact, and I'd like to rest on my briefs on that issue. However, regardless, I don't think that this court needs to even reach FAPA, because even looking at the statutes at issue, we complied and we were allowed to do this pursuant to the statute, pre and post FAPA. I see that my time is up. May I continue, or would you like me to rest?
Are there any further questions? I think we'll call it a wrap, counsel. Thank you very much.
Thank you very much, Your Honors.